Hey, welcome back to another episode of the Photographer Mindset Podcast. I'm your co-host, Seth Macy.
I'm your co-host, Aaron Manis.
Matt Patterson, it's been a minute since we saw you in Alaska. How have you been, my friend? How has the photo editing been?
Photo editing has been nonstop. Yeah, it has been a short minute, but it's, it was a long time there. It was lots of fun.
Do you miss us?
Oh, extremely. Yes.
Like out of 10. 10 like you're crying yourself to sleep. 1, you don't give a damn.
Oh, I would say it's a good solid. You don't want the answer.
Okay, that's probably true.
I do miss it. I do miss you guys. It was good. It was really, really good.
That's probably
Honestly, I have these moments. I was hiking yesterday. I've been trying to get outside a lot in the last few days, or in the last week, and just in the woods, struck with, God, Alaska's different than Connecticut. Just many times in the last.
That's profound.
Day. Taking photos of chipmunks and being like, this is not the same.
I have not taken many photos since I got back. Right? It's just I'm taking it in. Like you said, it's a lot different. Right? I go into the woods almost every single day, but it's a lot different.
Yeah.
Well, Matt, can you take us to school today? You are a patent and trademark attorney, for those who don't know you.
Right.
And I think we were coming back from our bear excursion when we really got chatting. I think every time we've met up, we've chatted about copyright, trademark, etc.
Right.
Obviously, because you can't help yourself. And I'm genuinely interested. But I remember our conversation on the boat, and I think I turned to you and said, you know what, this would be an incredibly useful conversation for a lot of photographers. So before we kind of pick up that conversation that you and I had for probably a half hour, 45 minutes.
Sure, yeah.
Which, because you're not short-winded. Aaron and I know that. You're very detailed, but that's what we want. It's a good thing.
Yeah.
It's a good thing.
You got to take the good with the bad, man.
Tell people what you do on a day-to-day, and then we'll talk about how I think photographers can protect a lot of their images with proper copyright filing, etc.
Right. Yeah. So I am, and thanks for having me. I really appreciate this. It's a long time coming, I guess, but. So I am an intellectual property attorney. Intellectual property is lots of things, but the 3 main buckets are patents, trademarks, and copyrights. And so I think today the focus is going to be on copyrights because the universe is so huge. And within copyrights, there's a lot going on. And so I want to talk about photography and how photographers and other artists can protect their works in copyrights.
Yeah, absolutely. I think to start, the biggest thing that you let me know is that people should be, correct me if I'm wrong, sending batches of their photos to, would it be the USPTO office?
Copyright office. Yeah. US Copyright office. So,
and
yeah, I mean, that's right. And so, copyright basics are that anything that's creative or rises to the level of creativity is protected by copyright in the United States. And the author or the creator enjoys the ownership of that copyright the minute it's reduced to a tangible medium. So if you sing a song out loud, nobody's recording it, it's not copyrighted. The minute somebody records it, boom, it's copyrighted. And the person, not the person recording it, but the person who sang it or played the instrument is the copyright owner. Okay. So it's the minute you reduce it to a tangible medium. Now, what we're talking about is going the next level and protecting it, right? By registering it, right? You can avail yourselves of copyright protection without registering it. It's just a really long road to hoe, right? Mm-hmm. And so for photographers who are prolific and want to be commercial and want to put their stuff out there, you want to be able to protect yourself, and it's really not that difficult. And then one of the things you pointed to, Seth, was that you can actually do these things in batches, right? Mm-hmm. at the copyright office, you can do batches of photographs. I think right now it's up to 750. Okay. And so you need titles for each one of them. It's a good idea to do it's a good practice to do like a spreadsheet of all the ones you're going to upload, and each one needs a title, and it can be very, very simple, but it's something you want to keep track of. And so, you can then batch 750 of these things. And what good does that do you? Well, if you then license somebody to use your image, and you guys have talked about licensing on the podcast before, if you license somebody to do your images, you're giving them a time window under which to use the photograph under the terms of the license, so how they can use it. So if they go beyond the term or beyond the scope of the license, you now have copyright protection to be able to go after them or have more teeth in a cease and desist letter. And you can just state that, the image is copyrighted and here's the copyright number and cease and desist. Or, there are statutory damages. That's the other huge benefit of copyright registration. You can avail yourself of statutory damages, meaning you don't even have to prove that you've been harmed. It's just that somebody has infringed or taken some of your rights.
Yeah, I think we were talking about how many photographers have just from their Instagram even haven't had a photo stolen.
Right.
And then it's this big, by often large companies that maybe don't know better. They should, or often just know. And they're like, whatever, this is Joe Blow. What are they going to do? And I think what we were talking about was if you don't have your images copyrighted, that can be a long process to get compensation or to, I guess, even just prove that it is yours.
Right.
Whereas you said if it's copyrighted, you have there's no argument that there's an infringement. And then I think the other interesting part was you told me that you can almost name your price for damages beyond a cease and desist.
Right. So, think about it, name your damages. Like I just had a client who got a cease and desist letter for using an image of Joe Biden giving a speech. Okay. And it was one of the, major publications organizations that sent the cease and desist, and the number they said to settle was $1,438. Like, I don't know where they come up with that, right? But it could have been $2,438. It could have been $5,000. It's a lot cheaper than getting into a fight with somebody over it. You're going to pay it, right? Mm-hmm. You're going to educate yourself that, geez, I guess I shouldn't have used that photograph from the syndicate. Right. Because, this is what happens, right? You should only use your images or stock images. I mean, we could talk about that too, but damages, can be, up to like $35,000 per use, right? Under the statutes. I think that's the number now. I mean, they do change, but right. You don't have to prove damages. They don't have to make sense, right? $1,438 makes no sense, but and the big thing is you want to stop people from using it. You're not really out there to make money off of somebody else using it. Litigation is never a good revenue generating strategy, but it's a good way to stop people in their tracks, right? That guy, I like his images, but he copyrights them. Maybe I should work with him and license his images legitimately, right? It's another benefit.
Yeah, I've had a particular instance, and often I've found that the outcome from reaching out to a business to stop using your image illegally often has a positive outcome. I mean, I reached out to a business that I'd done work for years ago, and they were using the work beyond the scope of the original agreement, just because they were dealing. The person I was dealing with had left the company, and the new person using it it was not on purpose. In other words, and I sent an email basically saying, "Hey, you can't do what you're doing," and the other end was pretty apologetic, and we ended up. I said, "Hey, like this could have, this has made you tons of revenue. Here's a dollar number that I would be comfortable with you sending me to make up for it.
Right.
By the way, if you ever need a
Right.
a professional photographer who will give you legal licensing and who understands that stuff somewhat,
Yeah. Yeah.
let's work together. And they're like, absolutely. So,
Yeah.
I guess when you have a settlement, in other words, it seems to be much more financially advantageous than getting sued if you're a business.
Right. If you get sued, you have to, hire a lawyer. It goes by the hour. You have to explain all the things that you did or didn't do, right? And in your diligence, what your defenses may be, whatever, versus I'm going to work with Seth on this. And so, but what you're talking about, I mean, it's a good point, right? So you license. The license is a contract, right? So you have a contractual arrangement with your licensee, right? But behind that are your copyrights, right? So you are licensing them within the term and the scope of that license. And that's a contractual obligation that they have to fulfill to you. You license to them, they pay you, they fit within those terms. If they don't, now you have a breach of contract claim against them, right? And beyond that, you also have your copyright, all the rights afforded to you by the copyright.
Yeah. Now, if somebody's listening and they're thinking, well, it's obviously my image. I don't have this image copyrighted. Why can't I just do this? Why can't I just send a cease and desist? And if they tell me to piss off, I can just sue them anyways. In other words, what's the advantage of having an official copyright in that circumstance?
Yeah. Well, the advantage is that now you have this independent agency, Copyright Office, verifying under penalty of perjury, because that's what you have to do when you register your copyright. You have this independent agency verifying, so you have this legitimacy vetted by an agency, right? That then you can say, here it is, it's on file, here's the number, right? And versus it's my image, okay, prove it, right? Well, I don't have the card anymore, or here it is on my hard drive, and that kind of stuff. So it really is linear, right? It's my image, here's the number, versus the back and forth of he said, she said kind of thing.
Right, that makes total sense.
I have a question, Matt. We're shooting bears together. We're shoulder to shoulder, and we click the shutter at the same time, essentially creating this very similar shot. And we send those both in to be copywritten. Is there any sort of like a common shot? Is there any sort of common law in this in terms of like, oh, well, there's 1,000 people there at the baseball game with the camera getting that same exact moment. You can't copyright that moment, that shot. Or is it very specific to like your data and your metadata that it came from your camera? And if they use that one, then that's the deal. So
you are both authors of the same of a similar image, but distinct copyrights.
Gotcha.
So you created your image, I created my image, Seth created his image, all of the same bear, but they're all slightly different, right? And they all rise to the level of creativity, right? What it took to take that picture, right? And you recorded it in a medium. Copyright's available to you.
Yeah.
Right.
Okay.
And if I license my thing, right, you can't squawk about it because it's not your thing.
Right. I think for everyone listening, I would venture that less than 1% of us are going through this process of sending in batched photos and copywriting them.
Right.
And yet without it, like you said, there is an avenue to prove, but it's just a lot longer. You gotta be organized. You gotta track down things. You might have to go back and forth. You might really have to prove that this is the time that you did it. And God forbid you switched hard drives or don't have the original file or whatever it may be. Just seems like a headache and much easier. So like you and I, we came back from Alaska with, 2,000 photos, 1,500 photos. Are we going through this process? Would you recommend going through this process with the photos that we find most important to us, with all photos that we're working with clients specifically? because I imagine this is somewhat financial and somewhat takes time and organization for people to go through with this. What's the recommendation in this day and age when we're taking thousands of photos of like which photos we're picking to actually go through with this?
So I think you want to work it into your workflow, right? Meaning we came back from a trip. We're going to down select, edit, and then pick from those edits. And so, okay, here are the ones that I think I'm going to include on my Instagram or, on my website, whatever your workflow is to get to where you're going to publish it. Before you publish it, there's reasons to do it before. You can always do it after, but you can group all of those photos. So now I'm going to add 100 to or 75 or whatever it is to my website, because these are the ones that I've gone through the editing in my workflow, and the ones that I think are going to make money for me. So you should make it part of your workflow. Now, if you're doing something year round and making commercial, shoots and things like that, then you might want to do it quarterly, right?
Mm-hmm.
You might want to do it every 6 months. You can only batch photos that are taken in the same calendar year, right? So that's why if you work it into your workflow, it may fit better than, I'm going to do everything from the last 12 months. Well, you can't do that if it spans the overlap of the year. So yeah, work it into your workflow, right? It's not very expensive. There's lots of tutorials on the copyright website. It's called ECO, ECO, right? Electronic Copyright Office, ECO. And it's free to create a username. You can go on there, you can play with it, you can look at the videos and teach yourself how to do it, right? It's not, the other areas of IP law that I practice, I try to couch people advise people not to do that, right? But with copyright, I think you can learn how to do it. And you can even run trial balloons, right? Because it's $75 unless they've changed the fees. Mm-hmm. And so, work it into your workflow and make it part of your process.
And I would imagine people that have a website and put up high quality imagery on their website and are trying to sell it, where someone can right click, save that image, and then use it. I've heard of people creating their own stores with other people's images and selling prints, and just their marketing is pretty good and they sell prints from other people. So I would imagine especially if you're trying to sell or use your prints in any way financially, this is super important to go through this process and protect yourself.
Sure.
Is that a fair?
And so, I mean, it's less important or less effective now is you can put up low quality images. Okay.
Right.
On your website. There's Gigapixel and others where you can make it better for people if you wanted to go through all that. But yeah, I think that it's much better to make it part of your workflow, register your copyrights, and move on. If somebody does take your images, then you have immediate recourse, right? And I had a client who did laser fat loss equipment sales, and they had before and afters, and they didn't register any of their copyrights, and their competitor took them and ran, right? And it took a lot of wrangling to get those guys back, because the images worked for them and they had a much better marketing machine than my client did, right?
Yeah.
So lots of anecdotal lessons learned.
So we're talking about incorporating the copyright process into workflow, which I think is brilliant. Question, at what stage do you think it makes the most sense? Pre-edit, after I've edited? Like what happens if What happens if I change the edit on a photo? Right? Should I be copywriting RAWs?
So it gets into different areas. I mean, it opens up the question. The question opens up a lot of areas. So it protects. So if you were to copyright the RAWs, right, then you own the copyright in those. It depends on the on the extent of the edits that you do. Your edits are what the result of your edits, the image after editing of a raw. It's called the derivative work. Okay, you derived the final work from your raw, producing a derivative work. Only the author has the right to produce derivative works. Okay, so you, by owning the copyright in the original, have the right to produce derivatives. Okay, so if someone else were to, so now you do a derivative, and you like that, and you post it, and somebody takes it, and they make a derivative of that, right? You still own the copyright, right? That original copyright covers you for derivative works.
Okay, got it. So just to be clear, if I've copyrighted the raw, I make an edit, which becomes a derivative work, and someone just simply steals the derivative work or makes a derivative of a derivative, they're still violating copyright from the original raw.
Correct. Yep.
Got it.
Yep. But the thing that it opens up, and we can get into this a little bit, but it's really a rabbit hole, is the whole AI portion of editing, right?
Right.
Like, who's the author now? When you take a raw and you edit it using AI techniques and produce a derivative work, who's really the author of that work, right?
I don't know. Who is?
Yeah. So it depends on the level of editing and the level of AI manipulation. Okay.
Well, because if my understanding is that AI technology is based off of real images. So let's say you add an arm or something.
Yeah.
Couldn't a photographer say, hey, that's the exact arm from my image that you've put onto yours? I'm suing you.
Yeah, it has to be a substantial amount. I mean, it's very dicey and it's a fluid area of the law. But like, if you take just take this as an example. If you take an image and drag it into like DALL-E or something, right? And say, make this into an artwork in the form of Picasso, right? And it makes a painting-like image from your photograph. You really don't own the copyright in that anymore, right? It's been substantially changed, right? To the point where you don't own the copyright in that. So who does, right? And right now, the Supreme Court has said nobody owns it.
Right? So what does that mean? So if I took a bear photograph, threw it into, I don't know what you used, DALL-E was what you said?
Yeah, whatever. Yeah,
and
whatever.
I manipulate it to be like a Picasso painting. I can't go and copyright that new AI artwork?
No, because who's the author, right?
Well, I would have assumed that it was a derivative of my work, but you're saying no.
Right, because a new image was created, right? But because it was substantially changed, a new image was created, and you were not the creator. You were not the author or the artist of that.
Interesting.
The AI bot was.
Right. So they're even, so they, being the courts, are talking about, is it the coders, the AI coders? Is it, because they write the algorithms that then, mine the, Picasso prints, if you will, right?
Holy. Yeah.
Teach the model. Yeah. I mean, that's what I said. It's a real rabbit hole if you get into the whole AI side of all this, right?
Yeah. You're really chasing the technology with the laws, right?
Yeah. I guess then we'll see the day when potentially could an AI model file a copyright?
So nope, because it's only available to humans, right? It's right in the statute. And so and it's really funny the way the law has developed in this area, because it's the whole monkey camera case, right? So a while back, guy dropped his iPhone into the monkey cage. Monkey took a bunch of selfies, right? And then the guy got his camera back, phone, I think it was a phone, and went to register those images. And Copyright Office said, you weren't the author, the monkey was. So the ASPCA, on behalf of the monkey, filed copyright applications for those photos, and they were rejected because the monkey couldn't be an author because he's not, or couldn't be the author. That's the term they use, is author, because it's not a human.
That's so interesting. So if I if I went to, here's an example. Okay. Remember I wanted photos of me using the Swarovski binoculars on that hike when we took a break. I handed my camera to Aaron because I wanted the photos to be on my camera, on my card. I didn't want him to have to deal with it. Said, hey, do you mind snapping a couple photos of me? I've just always assumed in that instance where you hand your camera to somebody, you say, take a photo of me and can you send me this? That I maybe own it. I guess I don't. So I couldn't copyright those.
Oh, I've already filed those with Matt, by the way.
Right. Yeah. Aaron owns them. Aaron owns them. So it gets into a different aspect here, Seth, right? So he can assign those rights to you. Okay.
How would he do that?
Well, he could do it, very simply by, just an email or an agreement, right? And if you go to copyright, then you can then copyright those images and say how you obtain those rights. You obtain those rights through contract with him, right? So, so that's how you can then register the copyright in that image that Aaron took, and then you'd be the copyright owner by contract.
Seth, Haley's ears are perking up right now.
Yeah, she's the author of a lot of stuff. She's the author of a lot of, yeah. So exactly. So, I mean, if, so I couldn't edit those photos, go to Swarovski and say, hey, do you want to license these? Because technically Aaron owns them.
Right. Unless he assigns those rights to you.
Because then Aaron would sue me and then the show would be over because we'd get in a big fight.
Yeah. Right.
Follow the money.
Isn't that what lawyers do? They just create fights, right? So
yeah, that's so interesting.
But it gets into another concept. It's a myth amongst photographers that if you get hired by somebody, the person who hired you, automatically owns the images, right? And so it depends on the relationship, right? Lots of times you're perfectly fine handing those images over because you've been paid a fair wage to do your work, right? And so the contracts that you sign with those people that you're working for typically have the magic words work made for hire, okay? So the works that you're doing are being made because they hired you. And so company A hires Seth, and Seth signs a contract that says works made for hire. Company A owns those images, right?
Exclusively.
They own them, yeah, right.
Yeah.
So they own all right, title, and interest, right?
So yeah, I think we talked about this too. So I feel like I've done this before. Aaron's done this before. Everybody has done this in their beginner stage, where you work with a company or a client just verbally. It's maybe not a ton of money, whatever, and they pay you and you hand them a folder of images. Is it assumed that you are giving up your rights when you do that?
It comes down to a bunch of factors, right? So absent an agreement, the author, the photographer still owns the copyright, right? Mm-hmm. Meaning the person who you handed them over to, company A, if they go to register your copyright, they cannot say that they were works made for hire because they weren't, right? They weren't contractually assigned because they weren't, right? And so there was no agreement. Absent an agreement, the author still owns them. The difference would be, hey, Seth, you're a photographer, come on set. It's our set. We just want an extra photographer. Here's a camera. So you're using their equipment, their setup, so it then becomes, you're more like an employee. So then the line gets blurred a little bit. Like, what did you really do? I would argue it would have to go a long way before you would give up your authorship to those folks, right? So, but lots of early people, people who are just emerging into the commercial world, they'd do anything to get their stuff published, right? But no, it's much better to get all of that defined up front, right? And assuming a company knows is a bad assumption, because lots of companies, even semi-sophisticated companies, don't know anything about copyright and who actually owns the right, title, and interest to those images.
Right. So just to be clear, absent of agreement, you haven't talked about licensing or who owns what. That doesn't exist. They pay you money in exchange for an agreed upon amount of assets. You give them to them, you are not handing over your rights, is what you're saying in most cases.
Right.
So what happens if that company said, oh yeah, like we just want them for socials, right? We're going to post them on our Instagram. And then a year later, it's in the cover of a magazine. Or let's say it's the banner
billboard
photo
in Times Square.
That's a little extreme, but like, let's say banner photo of their website.
Right.
Do I have any leg to stand on?
You do, but it's, and especially if you copyrighted it, right? Because then they would have to show that there was some rights in your registered copyright that were transferred to them, right? So the rights that you're transferring to them are for social, right?
Those rights just get transferred through conversation. Like those are verbal. Those are contracts, just text messages, even DMs, emails.
Sure, emails, DM, anything in writing is much better than a verbal, right? So it goes in that direction. Then a signed writing is the best, right? So that's what you really want to be pushing for, is a signed writing where both parties agree on what the terms are, and then you have to be savvy enough in your ability. And societies have these, like PPA and others have these form templates that I urge people to go and look at and use in their business. Some may think it's overkill. Some may think it'll scare people away, but guess what? It defines what your rights are, right?
Mm-hmm.
And so, yes, you're giving up some of your rights. You see copyright, all rights reserved, right? You see those on the footers of things. So the rights that you have not reserved to yourself, you've given away, right? So you've reserved all other rights except for social media. Right.
Yeah. So I'm learning right now. Mm-hmm. So have I given away those rights? Have I given away ownership of those images for socials in my example? Like now they own those photos entirely for socials, or do I still have some ownership? Maybe that's not the right word.
No. I think the word you're looking for is exclusivity, right?
Sure.
So if you sell them to company A or license them to company A for use in socials, can you still use them on your portfolio or your socials, right? So say socials, so that there's a total overlap of the use, right?
Yeah.
Yeah. Can you use them? Yeah. If you have not agreed that they're exclusive, then yes, right?
Mm-hmm.
Then you can use them, right? And there are other words you can use in a contract, like exclusive except as to the author, right? So you're reserving all rights to yourself, but then licensing somebody to certain rights, right?
Interesting. And I think a lot of people out there, and I'm speaking from my own brain, as someone that's a creative or maybe more on the artistic side than the business and law side of things, gets into the trap of like, I just hope they like them. Like, and that's that, and that's enough. And we hand them over, and we hand over the entire farm. And next thing you know, or maybe you don't know because the head's in the sand, they're using things in many different ways to improve revenue, to improve profitability, to improve their entire business, and you kind of get left behind. I do think it's important at least to explore like this conversation and get past the feeling of overwhelm. Like that's kind of the feeling that I get with this, is like, I'd rather just get paid for the job and be okay with it and kind of move on and not look into it too deeply and not have to like come into these problems and resurface them and be like, oh, they're using my thing in maybe a wrong way. I have to get into a conflict. No one likes that. So I think it is important to kind of hear this and learn from people. Seth's shared experiences on here where he's been burned. Luckily, as far as I know of, I haven't had many or big things, but it is one of those things that does happen, especially as you're trying to put your stuff out there, especially as you get better, especially as you're promoting different companies and products and clients. It's very easy for things to maybe not even on purpose, but be used the wrong way. And knowing this information, I think is very helpful as the first step for sure.
Yeah. So it's, right now it's knowing what you didn't know, right? So now you make people aware of things. You have these rights, you have these abilities to do things, but you're willingly going to give them up for whatever the opportunity is at this point in your career, right? So, okay, I'm not going to get paid for those, but I'm going to retain ownership, right? I'm not going to get paid for those, and I guess I'm giving away something. Well, at least now you know what you're giving up, right? So if you just give them away absent an agreement, it'd be a big fight to try and get them back, right? So, and a big fight against, something you made no money on.
Yeah. Right? We think of art as like this sort of abstract thing. Like, here's a photo, and I think also people get pretty good at photography pretty quickly, almost faster than they know all the ins and outs of what it can do. And we had Adam Capola on here talking about, man, like he's billing for thinking about a project, right. Which is the work that goes into making the project. Like, he knows every aspect of it and knows how valuable every aspect of it is. And I think, listen back to that. We want to have him on again, but that was an eye-opening episode as well, in terms of like how much goes into this and the value that it can incorporate. I think people get great at photography, and companies come like, hey, this is my example. Like, do you want a free jacket if you give us your whole portfolio of all the photos of you wearing that jacket? And it's like, yeah, sure. And we get really excited about the attention first, and then kind of maybe have to go through a bad thing before you realize, oh, like I gotta do this in a different way. And I think when it's abstract like that, I think a good way to think of it is you have a really expensive vehicle that you want to lease out to certain people to use. So like, you have a thing, a valuable thing that you're allowing them to borrow for a gala, a prom, whatever it may be. Here are the terms. You get to use my car for 2 days. It needs to be clean. You can't give it to someone else to drive. You need to have your light. Like, you have to think of it as an actual commodity that's still yours. That eventually comes back to you. It's not gone forever. You're not just handing over. And I think a lot of people think like, oh, I'm staying at an Airbnb and they're paying me $200 and I hand them a folder of those are theirs. That's their photos to do whatever with. And you can agree to do that if you want to, but understanding that they actually are yours and you have the say on how they are used.
Right. And I think that, the two of you have your viewers and listeners, you've given them lots of examples of, how we may jump in and do things, right? But if you aren't aware of what you're giving up, then you're really jumping in blindly. If you're willing to do it for that jacket, then okay, right? You knew you were giving up X, Y, and Z, of your rights to be able to get that jacket, right? But if you don't know what you're really giving up, then you're really not. It's not fair dealing, right?
Yeah, right. I think it's specifically difficult for beginners where they finally get attention from a big brand. It's like, oh my God, sweet! Like, I'm on my way. That's when the problem. That's when you want to be thinking about what we've just described, right? Right. One thing I like to do recently when pricing new contracts is, okay, what would how much money will make me not pissed off if this gets used in unlimited ways forever? Do you know what I mean?
Right. And what are your boundaries, right? Set your boundaries, mental boundaries, right?
Yeah. If this got used in forever in any way, what would I not be annoyed at? And trying to charge as close to that price as possible. Like, that's a very dumbed down version, I understand, but it's a good framework, because then you don't get pissed off or have regret when you see your content used in a certain way. Obviously working with contracts and licensing agreements, but that's still kind of a fundamental concept I like to think of, especially if they void a term. Obviously you would enforce that, but still, at least you're kind of you're somewhat covered.
Right. Again, that's a breach of contract, right? I mean, something for viewers and listeners to think about. That's breach of contract, right? You have an agreement between you and the other party, and if they don't live up to it, it's a breach, right? But I mean, back to your point, you go to Alaska. How much preparation did you do beforehand? You paid all this money to go to Alaska. You spent all this time in Alaska taking these photographs and these, and then you come back and you say, okay, what is that image worth to me, right? It's very difficult to put in terms of a dollar amount that you put in to get that one image, right? But the way that you're thinking about it is, what amount would you need to pay me so I don't get pissed off if I do see it, in the gray zone, if you will, right?
Exactly.
Yeah. So I think that's a good way to think about it.
Yeah, then you could choose to let it go or not. Right. You could be like,
yeah. It's searching. So in this gray zone, I have a great photo from Alaska. I license it to a company for a year. 3 years from now, am I still concerned? Like, are they following the rules? Am I back searching my photos? Am I just waiting for someone to say like, hey, this looks like your photo? Like, what are the chances that I'm going to run into a misuse of my photo? And is there another step that now I have to take under my belt and do yearly of like searching for my photos? Or is there a company that does that? You can load in all your stuff, or like, I don't know. You understand what I'm asking?
Absolutely. I mean, there are companies out there where, okay, so you take your golden nuggets, right? And you say, search, do a standing search on these images, right? Because I want not only compliance with my licensees, but I want infringers to be caught, right? So your contract says X, Y, and Z, and the company's going to send you updates. Here's how it's being used, right? Or we found no use of it, right? And you'll be able to go through the results of that. So there are companies that you can hire to do that, right? And I've never done it with copyrights, but I know that there are companies out there that do it. I do it with trademarks for my clients all the time, right? Is my trademark being infringed, right? So, and for trademarks, it's like $100 a year. So for copyrights, I'm sure, because you can automate all this stuff, right? There's a number of search engine, Google images, whatever, right, that are pretty darn good.
Yep. That's interesting.
One thing I've also been doing, I don't know if you guys do this during the Lightroom export phase. I don't know, Matt, do you use Lightroom?
Yes. Yep.
Yeah. You can link your Instagram account to your or you can assign almost like a copyright to be embedded in the metadata.
Yes. Yep. Yep.
What do you think about that kind of feature? Is that something people should be doing?
It adds to the amount of metadata that goes along with that image, right? So some people get rid of metadata, right? For whatever reason, file size or whatever it is, right? They get rid of metadata. But the more metadata, the better for you, right? So yes, I think that the copyright information that Lightroom allows you to tag into the metadata is really worthwhile.
Yeah, it says Lightroom allows you to embed content credentials during export, which includes your name, social media links such as Instagram, and the image's editing history, which I think is, why not, right? Why would you why not do that?
Right. So. Right. No, I think it's great. Add to that metadata, especially, in Lightroom, they automate it for you, right? Boom. Right.
Yeah. So can we run through a scenario just for people? Sure. Let's say runningworld.com stole my image from my Instagram. They saw it there and they used it on a blog post that's full of advertisements. So they're making revenue off of the article. How would I start? Where would I start? As I'm pissed off, I'm mad, I see that, I'm not getting paid. What would you advise people to do throughout that process?
So Runner's World, it's a
I'm just using it as an example. I don't want to get defamation here. Just
right. Some national magazine on running uses your image of a runner at the New York City Marathon.
Yes.
Boom.
Not Running World.
Not Runner's World. I've never heard of that magazine. So the thing to do is to look in the front of the magazine, right? Print magazine will have, the contact people listed there, the editors, right? So you find the correct contact for that listing, and you reach out to them and say, hey, that's my image, right? And I've copyrighted it. Here's the copyright number. If you haven't, right, you can say, I can prove through metadata, if need be, want to solve this amicably. So I would write a letter, right? If I were the owner, not an attorney, try to resolve it immediately if you think what you think you could get for it, right?
Yeah.
But if you can't solve it amicably, then I would hire a copyright attorney.
So I guess my question is, it seems like from when we've been chatting, cease and desist is kind of always the first move. Hey, stop using this.
Right.
And I think I said to you, if it were me, that's not enough. I see advertisements all over this blog post.
Right.
For you to just stop using it. Let's say the article is a year old or
right.
however, Google is still maybe it's a great article and Google's still indexing and a lot of people are reading it and a lot of people are seeing those ads. Right. I mean, for you to just stop using it isn't enough for me. Like I'm not getting paid, and
it's a win for them. Yeah.
Yeah, for them it's like, oh well, we got to use it for a year, okay, whatever. And I could see people maliciously gaming that system. So in that scenario, would you advise people, say, hey, cease and desist, and here's my number to make me
yes,
go away?
Yep. And that's exactly what the syndicate letter said to my client the other day. Was you had this in your blog post. I see you've taken it down, right? So that was not the same exact situation, but you had it up for a significant amount of time, and here's the number, right? And if you don't, we'll kick this over to our litigation department, or if you're an individual, I'll kick this over to my litigation attorney, who will be in contact with you, right? So you try to work through it. I mean, and I've never seen one of these actually go to court. Right. As somebody who takes an image that you have no rights to, what's your defense? Right.
I was going to say, it's probably pretty cut and dry if you have the paper trail.
Yeah. Or if you don't, right. What I'm saying is, if you're using an image where you have no idea where one of your employees got it from, right. You have no contract with anybody for that image. Where did it come from? Well, I lifted it off of Google Images. Well, Google doesn't own Google Images, right? All those images are owned by other people, right? Mm-hmm. They're up there for, Google can use them. It gets into the whole rights for social media, right? That when you post something on Facebook, they get to use it. They can't sell it to anybody else, but they can use it, right? So Meta now can use it, but they can't sell it to anybody. So it's up there, but you can't rip it and put it on your website and use it because you have no contract with that author. So like I said, I think that, if someone were to come to me, and I've had people do this plenty of times, they come to me, hey, I got a cease and desist letter and they want $2,000. Pay it.
Yeah.
Right.
That's great to hear. That's great to hear that's great to hear you say that from the side of the party that's in violation, and your legal advice is pay it, right? Because
they could sue you. Option, right?
That's the cheap option. They could sue you for a lot more. So I guess listeners, ask for a cease and desist and provide a settlement number that you feel is fair, that will make you, to my concept, not be pissed off.
Right. To your end of the continuum. I mean, you paying the settlement is just one step, right? Because what is the settlement, right? No, you're going to never use it again. Right. Right. This is a one-time settlement, or we can talk about licensing.
Yeah.
But I'm just saying, right. You want to know what that settlement is from both directions, right? So clients come to me and I say, pay the $2,000, but we want a release, right, from any future damages, and you agree to never use it again. Right.
Yeah. I guess what's the better route? Cease and desist, pay me damages, or hey, I see you really like this image that you've stolen. a little bit of sarcasm. Why don't you, to be able to continue using it legally, why don't you license it from me for $5,000?
Yeah.
Is there one that you think is maybe more successful?
So I think it depends on the publication and the use, right? So if you think that there's an ongoing thing, right, that where they might want something, you know, the best ones I've ever seen are like, imitation is the fondest form of flattery, right? That, thank you for, appreciating my image, blah, blah, blah. But, I want to be compensated for that. And we can talk about licensing, right? So, something that you think could be valuable to somebody ongoing, for sure, try to offer a license,
Right.
both for past use and future use, right? Because you want to get compensated for that past use, even if they thought it was innocent, right? You want to get compensated for that past use as well.
Yeah, I mean, because the example I provided earlier in this episode, where I reached out and said, "Hey, you're using these in the incorrect way." So what ended up happening is they were using these images that were just supposed to be for socials as advertisements on Instagram years later. And so every time I was getting the ads, I was getting the targeted ads. So every time, so what had happened is I had taken a photo of this product, right? And then what they did is, this particular product has a new version every year, and new designs. They would Photoshop the new designs onto the object. I'm trying not to divulge what this is. But you understand, they were using the original photographs to create more work, right? And then using those as advertisements. So every time I got an advertisement for a new design of this object, I would screenshot it, and I would screenshot it. And then eventually what I did was, so I emailed the owner and I said, "Hey, this was not our agreement a few years ago. I see you're using these as advertisements, so this image must be really generating you good business. Like, it's clearly valuable in this sense, right? They're using it as advertisements over and over and over again for different models."
Right.
You can either continue to use them for a licensing fee, which was like, I can't remember the amount, let's say $5,000, or you can cease and desist and pay penalties of like $2,500. These are arbitrary numbers.
For past use. Yep. Mm-hmm.
Or I can't remember if the cease and desist was more in penalties. I can't remember what costed more. Either way, I tried to get them to take the continue to use it and license it, just because I thought that would leave everybody with a better taste in their mouth. And the response was like, "Yeah, let's do that. So sorry. The person who had originally made the deal with me left the company. They had no idea. They thought they maybe took the pictures." Like, so a lot of these companies are just clueless. I guess that story is an example of how you can not go scorched earth. Like, take it down, pay me 10 grand, you bastards.
Right.
Sometimes people, it's not always malicious, and sometimes you can maybe spin it in a way that says, "I understand these are valuable to you. I have the proof. Here's the screenshots of advertisements you're using. You can keep using them for X dollars, or you can get new photography done, run new ad campaigns," which is more of a hassle than just paying me the licensing fee.
Right. Obviously, they liked doing what they were doing because they kept repeating what they were doing, right?
Right.
But so and there is another. We really didn't get into this, but it's called another. In that situation, you can avail yourself of what is called the DCMA, the DMCA, Digital Millennium Copyright Act, which means that if someone were to take your digital image and change it, take off your watermark, take off your signature, lift the product up, put in a new one, they've just violated the Digital Millennium Copyright Act, right? And so there's statutory damages there as well, right?
Right.
So it's more than just a derivative work, right? It's more than just a copyright infringement, right?
Yeah, I was saying you can't use the same image and background and everything and just plop a new design on the object every time. Like, that's crazy.
Right.
It's crazy town.
Right.
But people, I think people have this this fantasy that because companies are big and successful, they're put together and they understand everything and they know what they're doing, a lot of the time it's a firestorm. People just don't know.
Right.
And it's also a chance for you, like that person at that company, that owner will never make that mistake again. Right. And it didn't cost them a ton.
Right.
I have another question for you in this sense. I think a lot of people will find, I used to do this. I used to find inspiration on Instagram, and I would find a picture I liked on Instagram, and I would try to in an effort to improve my skills, I would try to copy it exactly how they did. And in that process, I would learn a lot of things.
Yeah.
If I take the exact images, obviously it'll be a little bit different. The lighting will be different. Maybe the position of something will be different. If I try to mimic a photo and then post it, am I violating a copyright of someone else with that derivative work if it's pretty much the exact same?
No. So if you took a photo of that photograph, there's not much in that, right? And so that would be a violation, right? It would be an infringement of the original copyright. But if you were to stage, say it's a product, right, on a turntable, whatever it is, and you're like, wow, I love that blue lighting or whatever, and I'm going to set it up, and you try to make the same image, and you come up with something yourself that is pretty darn close to that image, it's still your image.
Really?
Right?
So in other words, you can't copyright ideas.
You cannot copyright ideas, right?
So it's different just in the sense that there's some minute difference. See, that's surprising to me then, because then an edit is a derivative but protected from the original work. It's strange. This is a strange world you work in.
It is. Yeah.
But
one of the things to keep in mind would be, wow, I love what that restaurant did with its marketing. Look at that shot. So they did the outside, the inside, the color scheme, blah, blah, blah. And you recreate all that, right? And put it on your client's website, right? That could be, it gets into trademark issues, right? Where now you're copying a trade dress, right? The trade dress for that restaurant, right? Everybody sees those images and goes, wow, that's Chili's or whatever it is, right? But if you copy that layout and the color schemes and all that kind of stuff, right, and the images to make your website look exactly like that one, you could get in trouble for trade dress appropriation.
Because
right?
Not because you copied the images, but because it's so similar to the trademark that people could potentially confuse it with the trademarked brand or business.
It's the compilation, right? It's the compilation of those images to conjure a marketing campaign issue, right? That it's the compilation that even though you took the pictures yourself, you still own those pictures, but the way you assembled them may be a trade dress misappropriation issue.
Right. Whereas like in my example, let's say you were shooting a backpack and you were laying it on the floor and you saw a picture of a backpack on the floor with all these objects. And then I went and copied the exact same objects and laid them out the exact same way and took that image. I'm not violating a copyright.
You're not violating copyright. Yeah.
Right. Okay.
Yeah. Yep.
Look at it. It's
You're the author.
There's only so many chords in a song, right? I could completely copy a Beatles song progression, make my own lyrics, make my own vibe to it. It's the same exact chords, but it's going to be my own song. Can't copyright.
But see, I guess in my example, it would be like singing the Beatles song, but your voice is different, which in that world would be a violation.
Well, with songs, it depends on so the chords are copyrighted, right? So the chords, as long as they rose to the level of creativity at the time that they were done, right, and they were recorded, they own the copyright in those chords, right? I mean, that's typical of, even portions of songs today get into this whole copyright infringement issue, right? If you copy the chords of a song, right? So you can't just take somebody's song, change the words, right?
No, but that's melody too. So the melody, so there's just like a number of factors that have to be eerily similar. I would think, but there's only 12 notes on the scale. So there's many songs that have the same exact chord structure,
right?
But with a different melody, different lyrics. Reggae versus rock, just completely different feels.
Right.
Just like I imagine Seth and I have many pictures of bears, but they're different.
They're different.
but the same.
Yeah.
I'm actually
Even though they're the same bears, right? And
That's
you know,
what
something.
the other day, sorry, I wonder how many times this is false brought up where that's my image. No, it's not.
Right.
Seth and I were exchanging photos of a photo we took of whales, and we literally tricked ourselves twice by sending back and forth my photo versus his photo. And I was like, is that like, we edited it the same way, and we came to the conclusion that the lighting and the whatever just kind of put us into a lane of how to edit it with the colors and the light. But that looked, and we don't really always edit the same, or
Never,
I shouldn't
really.
say always. We have different styles. But this photo back to back, I was sitting there confused. Like, I thought he resent my photo back to me, just zoomed out or zoomed in.
He sent
like,
his photo, and I was like, is that mine? And then I sent mine, and he's like, why did you send me my photo? And I was like, what the hell is... We're like, we never do that. We don't have the same style. No, we don't. Mine's
I'm
a lot better.
Yeah, right.
Are
No,
there,
I was
are
going to
there
say.
false claims of like, that's my image? And then it's like, no, it's not. Close. But
Well, you
not.
have the metadata too, right? So
Yeah.
right. That's the nice thing, you know.
Mhm.
So that's why I was saying earlier, you know, you want to keep as much metadata as you can as you go through the edits, right?
Next time I'm going to take Aaron's camera and just blast off a ton of photos, and then he won't know which ones he took and which ones I did. And then it'll be a copyright disaster for him.
Right.
Smart.
Right.
Smart. Good.
Right?
No.
It's not the owner of the camera, right? So
My
Yeah,
camera
it's-
has the fingerprint recognition on it now.
It
There's
won't
an
go.
idea.
That's a good invention.
There you go. Yeah.
You a patent lawyer?
And you know, there have been issues with, you know, what if you set the camera up, you know, to take time lapse images, right? Who's the author? Well, you picked, you know, you as the photographer picked the interval, you set up the focus, so you're still the author of that, right? If you take your phone and you trigger it, right, remotely, you're still the author of that.
Here's what I'm going to do when I see people setting up a tripod to take like a family photo at a tourist attraction or something. I'm going to run up and I'm just going to touch the camera and be like, copyrighted.
You want that photo?
You want the photo?
You better not use it. I'm watching you.
And it's going to be a last to leave contest. I'm just going to keep my finger on their camera so they can't take another one.
Right. Yeah. I'm not sure that business model will work out for you.
Oh man, I was gonna quit everything to do that.
Yeah.
Just stand at the Grand Canyon, and every time somebody sets up a camera on a tripod, I just go and put my finger on it. Mine.
Right.
Perfect.
Well, Matt, thank you for today, man. That was very helpful. Thanks for taking us to school. I know we could go a lot longer, but an hour of copyright law is great, I think.
Yeah.
Yeah.
An hour wide and an inch deep, right? Holy cow. I mean, there's so much here, right? So
but I hope people left kind of with a little bit more confidence about their rights and how they can protect themselves and what to do when. I'm not saying if, I'm saying when their photo gets stolen or used incorrectly or whether maliciously or by accident. You have things you can do, clearly. And if you're ever in that scenario, revisit this episode.
Yeah.
You know,
and Matt's a
this
photographer too, by the way. So Matt, where can people find your work? Take a look.
Well, so as an IP attorney?
No, I meant as a photographer, but you could do both.
A photographer, yeah.
Well, we'll put links to your IP attorney in case people need a patent lawyer or a trademark lawyer. We'll put that in the episode description. And, you know, of course, we'll put your photography website. But tell us about your photography.
Yep. So my photography is Wild Shot. So my website is wild-shot.com. And I am up at Birch Hill Tavern, our favorite haunt in town. I have a number of pictures up there, and I'm showing at the Glastonbury Art Festival in September, weekend after Labor Day.
Awesome.
And you're at the Bradley Airport, sir.
Yeah. And I'm at the Bradley Airport, Bradley International Airport. Yep. I have 6 images up there, big images.
Matt used Whitewall, folks. That's our shameless plug, our sponsor of the episode.
I love Whitewall.
It's good stuff.
It's excellent quality. Comes shipped very well. Comes shipped very fast. I didn't know it was coming from Germany. I get a UPS notification, right? And I'm like, what the heck did I order from Germany 6 days ago? Boom! It's on my doorstep, right?
You go metal?
No, it was fiberboard.
Cool.
Bradley Airport dictated fiberboard, so that's what I did.
How many prints did you put up?
6.
6, right? Yeah.
6.
And I think that I have like 40 by 30, right? The
Incredible.
images are 40 by 30. So
Very cool.
yeah.
Good stuff. Well, Matt,
Gate 24, go take a selfie, post it on social media.
yes, if you're in Hartford,
If you're in
Connecticut, or you
Connecticut,
fly
right,
into there,
yeah.
go to Gate 24 and see Matt's artwork.
Yeah.
Right. So
Someone's listening. They just got off the plane. They're like, no way.
right. There's going to be a big flock of people there. Yeah, I can see it now.
Right? All right. Until next time.
Good. Yeah.
Bye, guys.
All right. Thanks, guys.